Good afternoon, everyone. Bailiff, can you see and hear me okay? You're on mute. I'm going to prompt you to unmute that one.
Here's now.
All right. Yes, sir. Thank you very much. Who do we have in the courtroom, the jail courtroom that's ready?
We got Austin Doe. Austin, step on up here.
And who is Mr. Dole's attorney?
Casey Ashton.
All right. Is Mr. Ashmore there with you in the jail?
Yeah, stand by on the ground.
Mr. Dole, just go ahead and have a seat there behind you. We'll wait on Mr. Ashmore. Go ahead, Mr. Sanders. Are you ready on your client?
Yes, Judge, we're ready on Mr. Carmona.
Sorry, Bailiff. I told Mr. Dole just go ahead and have a seat.
Okay.
You ready on Mr. Carmona? All right, let me get back to him. Is he set this afternoon?
Yes.
All right, you ready, Stella? This is cause number CR 24-3, State versus John Michael Carmona. So understanding that we were set for a plea today. Is that right, Mr. Sanders?
Yes, Your Honor, and we had reset it from January because of some health issues and Mr. Carmona having surgery on one of his eyes, and he has surgery for his, I believe, left eye or the other eye set for this Thursday. So I talked with the state to see if it would work to reset the plea. Probably if we could have it reset 6 months or 6 weeks, maybe the end of March. Because after he has the surgery, he's got to wait a couple weeks and then go back in the hospital to basically have the blood behind his eye vacuumed out. And so we were trying to at least get some of those major issues taken care of before he would go to jail.
State, do you have a position?
Yes, Your Honor. So Mr. Sanders has provided me with some medical documentation confirming all of these appointments and all these medical issues. We do have a plea agreement to proceed for county jail time under 1244A. I have no objection to a reset to 6 weeks, and we will either come up with some creative alternative plea agreement or have Mr. Carmona's medical issues worked out in that time.
Okay. Mr. Sanders, are you available on March 23rd?
Judge, actually, I was going to say, would the 25th work? I know I've got a hearing set in Smith County the 23rd.
Yes, I think the 25th would work.
Okay.
Is that the date you prefer?
Yes, if we could do that, that'd be great.
All right, court sets Mr. Carmona for plea before the court on March 25th at, we're anticipating that he'll go into jail on that day, so we'll just do it at 1:30 also.
Okay.
Okay. All right, Mr. Carmona, make sure that you stay in contact with your pretrial release officer, and we'll see you back on March 25th, and you're free to go.
Yes, sir. Thank you, Judge.
You're welcome. Do we have Mr. Lunsford available in the jail? He up there in the jail courtroom?
No, he's not in here right now. I brought
Okay.
the first 3 up.
All right, thank you.
Who do you have in there with you, bailiff? Besides,
I got Raymond Howard and Jeremiah Holmes. You gonna do Mr. Holmes real quick? Casey's ready for him. Who?
Jeremiah, okay, so Jeremiah Holmes.
Howard. He's ready for Mr. Howard.
All right, Mr. Ashmore, are you ready on Mr. Howard?
I am, Your Honor. As I understand it from Ms. Patty Tabram, your coordinator, Mr. Howard has, as of today, hired private counsel. So I believe I'm going to be substituted here momentarily. Just so the state's aware, there's the court's aware, there's 5 current charges. I think there's 2 unindicted, and the current offer is 40 to resolve all of Mr. Howard's business in Van Zandt County, Texas. I understand he wants to go in a different direction, and appreciate the opportunity to represent him and see where that is, and we'll get the rest of that squared away.
Be that as it is, I don't have any motion to substitute counsel on this case. So right now, the court only recognizes you as the attorney. And I believe my coordinator has told Mr. Crane, and Mr. Crane is not even aware of today's setting. So we have an individual who is not an attorney on this case right now. So until the motion to substitute counsel comes in, gets before the court, and the court can rule on it, then we're going to move forward on Mr. Howard's case.
I understand that, Your Honor. I guess I would request just a moment to step off and have a word with him. I got here early to visit, and it's probably my fault, but I was in the visitation and they were in here. So I was, anyhow, been here for about an hour waiting to talk to him and Mr. Dull. And like I said, just ships in the night, probably my fault. So if I could have a moment to visit with Mr. Howard about what he wants to do to resolve this or what have you, I would appreciate it very much.
Well, let me ask you this. Are you prepared to announce on pretrial on Mr. Howard? So he's got 5 cases I see, and it looks like 4 of them are set for pretrial. 1 of them set for docket call. The court could entertain whether or not you had any contested pretrial motions, then we could set for docket call. And if another attorney files a motion to substitute, then the court could take that up in the interim. Are you prepared?
Judge, I'm sorry. I didn't realize you were speaking. Forgive me. No, I did not anticipate filing any pretrial motions. I think any pretrial issues there are thoroughly addressed through the Van Zandt County standing order. I don't see any 3914 issues that we don't have discovery on, especially since the state's prior position was they were not going to present to grand jury these 2 other potential unindicted cases. Those would not be introduced as potential other bad acts, and seeing if we could resolve this via plea bargain. If those 2 cases are presented to grand jury, or they are going to be additional evidence of unindicted, 404 evidence or evidence of other, criminal bad acts or pattern in conduct, then I think that might lead to that. But again, I think the Van Zandt County standing order covers all that. So I didn't anticipate any pretrial motion.
Okay.
I don't see the need for any at this time.
All right. Then this is what I believe we should do is I'm going to find that there are no pretrial motions filed, contested pretrial filed and requested in cause numbers CR 20-252, 253, 254, and 343. So the court is going to set all of these cases for docket call on March 23rd. Do you have any scheduling issues on that day, Mr.?
No, I've already looked at that date, Your Honor.
Do you know if you're due to be here on the 23rd already, or is there another date that you're going to be here that would be more convenient for you?
I think no, I'm already supposed to be here. We already have at least 1 pretrial that day, Your Honor.
Okay, so Mr. Howard's going to be then set for docket call in all of his cases on March 23rd at 1:30. And so, Mr. Howard, what that means for you is that if you're hiring an attorney, or if you have hired an attorney, that attorney will need to file a motion to substitute so the court can rule upon that. And then if the court grants it, then Mr. Ashmore will be relieved as your counsel, and your new counsel can come in. But as of right now, no other attorney has filed a motion to substitute with this court. Okay. So no other attorney is being recognized at this time, and Mr. Ashmore is not going to be discharged. Because if I were to discharge him and, some attorney that you hired never files a motion to substitute, then you're sitting here without counsel. And I've got to make sure that we we protect your rights. You understand that?
Yes.
Good. Okay. So if your attorney files a motion to substitute between now and then we'll take that up, and then your new attorney can appear on March 23rd. All right. All right. Thank you, Mr. Howard.
Judge, I need just a moment and I'll be ready on 3 cases, but.
Okay,
like I said,
that's
I was in visitation and.
I know you're working. I know you're working. Go ahead, and I'll try to take up some of the other matters.
Thank you so much, Judge.
Judge, Mr. Woodwhite said he's in the waiting room and he would love to be let in on the fun.
He doesn't want to sit out there and read magazines. I'm looking at the waiting room. I don't see Mr. Woodwhite. I see Vincent's iPhone and a phone number. I don't see Mr. Woodwhite. He's in someone else's waiting room, I'm afraid. Mr. White. There.
Yes, sir.
All right, all right. I believe that Mr. Ojeda, if I'm saying that correct, he's your client, is that correct?
No, Judge, he's mine.
Oh, I'm sorry, Mr. Ashmore, hang on.
No, that's okay. That's a super quick one. We can do that one fast if you want to call.
No, go ahead. Mr. White, I'm sorry, you have Cody Pickett and you have Kelly Lambert. And so we don't have Miss Lambert brought up yet, but we can go ahead and announce on Mr. Pickett. This is cause number 2017-410 and CR 17-107, State versus Cody. And I have a note that we have verified that he's still in the Tarrant County Jail. Can we have a update on his status, Mr. White, if you have one?
I believe the court, Mr. Cox submitted a motion to dismiss on December the 16th. And I believe the court signed it. I have one copy of the order on one case, and I believe that they had dismissed the misdemeanor prior.
Okay, let me see why that's still on my docket. All right, the court has dismissed cause number CR 17-107 on December 16th. So that'll be removed from the docket. And what did you say on the misdemeanor? Did you say it was dismissed as well, Mr. White?
It should be dismissed. I have not got a copy of the dismissal on that, but Mr. Cox had indicated to me that he was going to dismiss that as well. But obviously, I don't know if that'd be down in the county clerk or not.
Judge, the DA's office records show that in both cases, Mr. Cox moved for dismissal. I don't know if it was signed downstairs. I will look into that and make sure that is, if it's not been done, it will be done in short order.
Well, I've reviewed Judge Winters in the clerk's filing. Judge Winters dismissed that on December 16th as well.
Thank you, Your Honor.
We'll remove him from the docket. Thank you for that, Mr. White. All right, Mr. White, we'll just wait on Mr. Lambert when she's brought up.
And does the court have the plea papers on that?
Yes, I do.
Yes, sir. Thank you.
All right, Mr. Sanders. Who else had? Mr. Ojeda, did you say that was your client?
Oh, no, mine's Mr. Lunsford.
Okay, I'm sorry. Who is the telephone?
She's here. Let me go get her. There it is. Brianna, she just had a brain fart. She was on the 9 o'clock meeting. I told her to be on the afternoons and I have to ask for recess. She is going to, she can't get here today. She just totally misunderstood the whole years. She was a Louisiana resident. She got in trouble. So. Yeah. Yes, and she thought she was going to do this all electronically. I'm like, girl, we need your phone. You don't understand. Okay, I will get that. That I can do right now. I'll have that done right now. Okay. Yeah.
For the record, for the state's benefit, CR 20-342, State versus Jeremiah Garin Holmes. He was set for arraignment today. Ms. Beasley filed a waiver of arraignment that was granted. Court has set that for pretrial on March 23rd at 1:30.
Thank you, Your Honor.
You're welcome. We're not going to be bringing him up.
I have him going back there getting Kelly Lambert right now.
Okay, thank you.
That was this morning. Yeah, you did. Did I?
Mr. Sanders, do you have Mr. Key with you at all?
Not right now, Judge. I know that he was running late this morning, but did get here. And after we had basically reset it for him to come back this afternoon, he went over to pretrial, met with Mr. Waddell, and I'd even texted Carl while we've been waiting here, and he had the understanding that Josh knew to be back at 1:30. And I've tried to call and text, but I haven't gotten a response from him. So I know at least he was late this morning for what he said because of issues with his truck. I was hoping that he would just wait around Canton for court this afternoon instead of trying to go back home, but I think he went back home closer to Maybank, I believe. So I was still going to try again to get in touch with him.
Okay.
Hey, Aaron, I got one more coming to you. That one back. What's your name, Jeremiah? Have a seat. Let me know when you're ready for Ms. Lambert.
You have her ready?
Yes.
Yeah, come on up, Ms. Lambert. Ms. Lambert, can you see and hear me okay?
Yes,
And can you see your attorney, Mr. White?
I sure can.
All right. Ms. Lambert, it looks like you have reached a plea agreement with the state to resolve your case. Is that correct?
Yes, sir.
All right, Ms. Lambert, I'm going to have you raise your right hand. I'm going to place you under oath. Ms. Lambert, do you swear, go ahead and raise your right hand. Ms. Lambert, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. All right, you are Kelly Longoria Lambert, is that correct?
That's correct.
And Ms. Lambert, are you a United States citizen?
Yes,
Do you read, write, and speak English?
yes.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Absolutely.
You feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
I sure do.
Is there anything about your plea agreement that you've entered into with the state that you do not understand?
No, sir.
And Ms. Longoria, throughout the paperwork, I see a signature on your signature line. Let me ask you, is that your true and correct signature?
Yes, it is, sir.
And if your signature appears throughout, you're telling me that you only signed this after reading the documents or having them explained to you. Is that correct?
That's correct.
And Mr. White, is it my understanding that the plea agreement is that your client is going to be true to all counts contained in the state's motion to adjudicate, which appear to be 9 counts, in exchange for the state's recommendation that her community supervision be revoked and punishment be assessed at 9 months state jail with a balance of her financial obligations and 88 days credit towards her sentence?
Your Honor, that's our understanding of the plea agreement. I would also note to the court that I believe that Ms. Lambert is mentally competent, that she understands the proceedings that are pending against her here today. And I believe that all the waivers that she executed were done so knowingly, intelligently, and voluntarily.
Thank you. And does she waive the formal reading of the state's motion to revoke at this time?
She does, Your Honor, and pursuant, we're going to enter a plea of true to all 9 counts.
Okay. All right, Ms. Longoria, you appeared before the court on September 19th of 2019 regarding the charge of possession of a controlled substance in penalty group 1, less than 1 gram, a state jail felony. On that date, the court heard the evidence, found that there was enough evidence to convict you of this offense, and the court found that you were guilty and assessed your punishment at 2 years confinement in the state jail division of TDC. The court did not impose a fine at that time, and the court also suspended your sentence and placed you on community supervision or probation for a period of 3 years. And it was during that period of 3 years that the state has filed a motion to revoke your community supervision. They filed that on October 1st of 2020. And you have been given an opportunity to review that motion with your attorney, Mr. White. Is that correct?
Yes, sir.
So at this time, Ms. Longoria, it has alleged in 9 separate counts, various ways that they allege that you violated your probation. Having reviewed that, how would you plead to all counts 1 through 9? Are those counts true or not true?
True, sir.
And Ms. Longoria, are you pleading true to each one of those counts individually because those counts are in fact true and for no other reason?
Yes, sir.
Has anyone threatened you or forced you or made you feel like you had to plead true to any of these counts?
No.
All right, the court will accept Ms. Longoria's plea of true to each count as contained in the state's motion to revoke. Mr. White, is there any objection to the admission of the defendant's waiver of rights and plea of true?
No, sir.
All right, court admits that into evidence. It takes judicial notice of Ms. Lambert's judicial confession. Is there anything further from the state?
Nothing at this time, Your Honor.
Anything further from the defense?
No, sir.
All right, Ms. Lambert, based on the court's review of the state's motion to revoke, in conjunction with your plea of true, court's going to find that you have, in fact, violated the terms and conditions of your community supervision. The court hereby revokes your community supervision and assesses your punishment in accordance with the plea agreement that you have reached with the state. The court hereby sentences you to 9 months confinement in the Texas Department of Criminal Justice State Jail Division. Court also orders you to pay the balance of the financial obligations previously imposed, including court costs and any reimbursement fees. The court hereby awards you 88 days credit for the time that you have spent in jail on this cause. Do you believe that constitutes all of your back time credit you have on this case, Ms. Lambert?
I believe so.
Okay. All right, Ms. Lambert, you're hereby remanded to the custody of the Van Zandt County Sheriff to carry out the terms and conditions of your sentence. Once you are released from TDC, Ms. Lambert, I'm going to order you to report to the Van Zandt County Courthouse, or at least call the Van Zandt County Courthouse and speak with the court compliance officer so that you can make arrangements to pay your financial obligations in this case. Your failure to do so will result in a warrant being issued for your arrest and you being rearrested and brought back before me. So it's very important when you get out to contact the courthouse and speak with that compliance officer, okay?
Sir, can I pay them earlier? Like, can I pay them today or?
Yes, ma'am. You can pay them today if you want to have a family member come and pay that, or if you have it there in the jail, I'm sure we can make arrangements for doing that. Yes, ma'am.
Okay, I'll try to take care of it today.
All right. Well, thank you. And we would appreciate that, Ms. Lambert. Do you have any other questions at this time?
No, that's it.
All right. Good luck to you, Ms. Lambert.
Thank you very much.
And I believe that you've already been fingerprinted by the bailiff. Let me see here. No, you have not been bailiff. Is there any paperwork over there? I don't have a fingerprint on this judgment.
I won't say where, look.
No, Lambert.
No, there's no paperwork over for Lambert.
Okay, then we'll have to send some paperwork over there and have her fingerprinted.
Thank you, sir.
Thank you.
Ms. Lambert.
What's your name? You ready for Lunsford?
Depends on if Mr. Sanders is ready. Mr. Sanders, are you ready on Jerry Wayne Lunsford?
Yes, I'm ready.
All right, step on up, Mr. Lunsford. All right, this is cause number CR 1642, State versus Jerry Wayne Lunsford. And I believe this is a hearing on Mr. Lunsford's motion to revoke. Any announcements, Mr. Sanders?
Yes, sir. Judge, we have an agreement worked out. We were talking more with the state this morning and talking more with my client. We just don't have all the plea papers ready to turn in to do the revocation today. I don't know
And
if we can
Mr. Sanders, we do actually have those paperwork, that paperwork available at our office. It's in the
Okay.
lobby. So if you're available to come get that and then perhaps go out to the jail, we are ready to proceed today.
Okay. Yeah, that'd be fine. We can definitely do that today. That works for me.
Okay, then, Mr. Lunsford, what we'll do is I will have you have a seat and I'll call your case in a little bit later this afternoon. And I believe Mr. Sanders will bring some paperwork to you and you'll be able to do your plea agreement today.
Yes, sir.
Okay.
And Judge, do you want me to go ahead and keep this pulled up on the laptop in the on the
Yes,
third
sir.
floor?
Yes, sir, that's fine. You can just leave it
Hopefully-
open. That way, if we
Okay.
need to use it, we can go in there and lock it and open it back
Okay.
when that needs it. And if Mr. Key shows back up, then we'll just have him sit there and wait on you.
Okay. All right. That'd be great then. Thanks. And yeah, I'll
Thank you,
go get the
Sanders.
paperwork and get that done.
Carmona sitting out there.
Is Mr. Ashmore ready on his clients?
No, he's not. We have, John Williams up with Bill Stevens.
Mr. Maroney.
And Mr. Maroney.
Yes, Mr. Maroney, I believe Mr. Merleader's ready. I haven't seen Mr. Stevens yet. Mr. Merleader, are you with us still? All right, are you ready on Mr. Maroney? Mr.
Sorry
Maroney?
about that, Judge. Yes, I'm ready.
Okay, this is cause number CR 2219 and 340 and CR 2348, State versus Philip Ray Maroney Jr. I believe we're set for docket call on the possession of controlled substance case, less than 1 gram, and pretrial on the 1 gram to 4 grams. Any announcements, Mr. Merleader?
Judge, I've reviewed all the discovery from both of the cases, and I'm not sure if the court remembers, but the court forfeited Mr. Maroney's warrant last time he was in court, and he was picked up on a new charge for possession of a controlled substance. So currently there are 3 charges for a controlled substance. 2 of them are indicted, and 1 of them is unindicted. I don't have any pretrial motions for any of the indicted cases. And I did receive a plea offer from Ms. Heisel on February 3rd. I sent Mr. Maroney a letter. I wasn't able to make it to the jail, but I sent him a letter on those 2 different plea offers. And I would like to request a reset from the court so that I can counsel him on those 2 offers, which would resolve essentially all of the cases that he has in Van Zandt County, Your Honor.
Mr. Merleader, remind me, are you available on March 11th?
Yes.
All right, so what the court's going to do is set Mr. Maroney, both of Mr. Maroney cases for docket call on March 11th. And that should give you time to counsel your client on whether or not he wants to take the plea agreements or the plea offers. And so that'll put each case set for docket call at the same time.
Okay. That's good, Judge.
All right, Mr. Maroney, any questions? You understand what we've done here today?
Yes, sir.
Okay.
Lord, my bond, I sent you a bill from the jail on a bond reduction.
So, Judge, if I may, I've explained to Mr. Maroney that even if I did file any kind of bond reduction motion, the court would be most likely not be granting that based on his past behavior and the charges that are currently pending. And also because he is indigent, I told him that I'm his court-appointed attorney, and I'm not going to be filing any bond reduction motions. And the court doesn't pay attention to any pro se motions that defendants file themselves. I explained to him if he wishes to hire counsel to do that, he can certainly do that. But I'm not going to be filing any bond reduction motion for him.
So when I sent it to him, ain't nothing.
Mr.
I don't understand how that works.
Mr. Maroney, hang on, Mr. Maroney. Let me respond to Mr. Merleader. So thank you, Mr. Merleader, and I'm going to find that you have admonished him correctly that the court is not going to entertain any pro se motions when indigent defendants are represented by counsel, and you are also correct that the court would not entertain a motion for a bond reduction or a PR bond at this time, as the court has taken notice of Mr. Maroney's cases and why he's in jail today. So we're going to set Mr. Maroney for docket call on March 11th. And if Mr. Maroney wants to hire an attorney between now and then, he may do so, and they can file a motion to substitute counsel. All right, go ahead and have a seat, Mr. Maroney.
Judge, that's all I have. May I be excused?
Yes, you may. Thank you, Mr. Merleader. Good to see you.
Thank you, Your Honor.
Who you on next, Judge?
Do you have Gandy? Mr. Ashmore still working? Can we get Mr. Gandy?
Mr. Andy in here, step on it. Yes, sir, he's here.
Okay.
Yes.
All right, this is cause number CR 2120, statement Andy. We're set for pretrial today. Mr. Elliott, any announcements on pretrial? Do you have any contested pretrial motions?
Your Honor, I believe there are no pretrial motions. We've received the discovery. I've actually been able to view the video and at least hear the audio and talk to my client. He was just placed in jail on a bond revocation about 2 weeks ago, a little less. And I haven't had an opportunity to go back out there and discuss the most recent offers. I think it's the same offers. And if I could talk to him and then talk to the DA with a resetting, or even if it's just a docket call that you've been doing on the rest of them, I'm fine with that. I need time to talk to the DA's office and to my client.
Okay. Court finding that there are no contested pretrial motions filed in this matter, the court will set this for a docket call hearing. Do you prefer, I've got 3 dates available, March 11th, 23rd, or 25th. Any of those days better than the others?
Bear with me 2 seconds while the computer pulls up. I'm not sure what all dates you said, but I'm wide open on the 23rd in the AM.
With Mr. Gandy being in jail, it would be a PM docket. What about PM?
I'm free between 1:30 and 2:30 if that's when we'd be able to be in.
Okay. Court hereby sets Mr. Gandy then for docket call at 1:30 on March, and you said 23rd, correct?
Yes, Your Honor.
All right, so we'll see you back on that date, Mr. Gandy. And if you make bail, Mr. Gandy, then your hearing will be at 9 a.m. If you're in jail, it'll be at 1:30 p.m.
Yes, sir.
All right.
Yes, sir.
Do you have any questions?
Yes, sir. Is there any way I could get a bond reduction?
Yeah, that's a question for your attorney, and Mr. Elliott will advise you on that.
Okay.
All right, so you can go ahead and have a seat.
Yes, sir.
Mr. Elliott, do you have any other business today?
No, Your Honor.
Thank you, sir.
Thank you, Judge.
We have John Williams, you have Bill Stevens.
Mr. Stevens has not joined us yet, so I'll have him.
Okay, Mr. Ashmore's still back here visiting, so
Okay, we'll give him,
it looks like we're tied up with him.
yes, sir. Mr. Ashmore, who do you have with you at this time?
Have Miss Tatiana McKnight, and we have a pretrial intervention contract before Your Honor this afternoon.
All right, and can you give me the agreement and the terms of the pretrial intervention?
Yes, Judge, this is arising from an allegation of injury to an elderly. Ms. McKnight was a social worker and caregiver in a mental health elder care facility, and there was an incident with one of the patients, and she took some actions to defend herself, that the state gave rise to these allegations. The agreement is that because of her always being a good citizen and no criminal history, that it's a contract that she's subject to for 2 years. The pretrial intervention program fee of $500, which she has in a money order or cash today, and no restitution or reimbursement fees, 100 hours of community service, and that she continues to be faithfully employed in her social work or other gainful employment. And then the court-appointed attorney's fees of $750 to repay that to the Indigent Defense Fund of Van Zandt County, Texas. And within 90 days from the signing of this contract today, taking an anger management course as approved by her community supervision officer. We talked about that before this hearing. And any other anger management counseling as may be directed by Van Zandt County Adult Community Supervision, and whether or not they would want her to do a polygraph is, that's a variable that is part of the contract, but it's not required. So those are the 3 conditions of the PTI and the other monetary responsibilities, which she's aware of.
Is the name charge injury to an elderly individual a 3rd-degree felony?
Yes, Your Honor.
Okay. And has Ms. McKnight signed all of the pretrial intervention contract paperwork?
She has, Your Honor.
And that's been witnessed?
It has not been witnessed. I don't think we have a clerk.
Hey, Ms. McKnight, if you will, raise your right hand. I'll put you under oath. Ms. McKnight, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Ma'am?
Yes.
Okay, make sure you speak up because I can't hear you. You can put your hand down. All right, you are Tatiana Toinette McKnight, is that correct?
Yes.
And Ms. McKnight, you a United States citizen?
Yes, I am.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes.
Do you feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
Yes.
Is there anything in the paperwork that you do not understand?
No.
Throughout the paperwork where your signature appears, are you swearing that that is your true and correct signature and you've only signed the document stating that you understand what's in them?
Yes.
Ms. McKnight, do you understand that if the court approves this agreement today, you would be waiving several important constitutional rights? Do you understand that?
Yes.
Do you understand that by entering into the pretrial intervention contract, you're going to be waiving your right to a trial by jury?
Yes.
You understand that you would also be waiving your right to have your criminal records expunged with regards to the Van Zandt County DA's office and the Van Zandt County Probation Department. Do you understand that?
Yes.
Do you understand that by waiving your right to a jury trial, you're also waiving your right to cross-examine and confront the state's witnesses and their evidence before that jury?
Yes.
Has anyone threatened you or forced you or pressured you to get you to waive your right to a trial by jury?
No.
All right, the court's going to find that Ms. McKnight has intentionally, knowingly, voluntarily waived her right to a jury trial and that she understands the limited waiver of expunction with regards to her criminal record. Ms. McKnight, do you understand that the range of punishment for a 3rd-degree felony offense of injury to an elderly is not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that?
Yes,
If you are put into this program and you subsequently violate the contract, you understand that you're stipulating evidence, meaning you're telling the court that the criminal offense reports are admissible and the state could use those against you in their prosecution. And if the court bears their burden and proves that you have violated the terms and condition of the contract and they use the evidence therein, then the court could potentially find you guilty of that offense and could assess your punishment anywhere between 2 years and 10 years after a trial. And the trial would be before the bench, not before a jury. Do you understand that?
yes,
And this is the agreement that you've reached with the state, and this is what you're asking the court to approve today, right?
yes.
All right. And has anyone pressured you to enter into this pretrial intervention contract, or are you doing so of your own free will and accord?
On free will.
Okay. And Mr. Ashmore, you've explained to Ms. McKnight the advantages and disadvantages of a pretrial intervention contract regarding the stipulation and admissibility of evidence.
Yes, Judge. Both at this hearing and in our previous in-person hearing around December 17th.
Okay. All right, then, based on the evidence and statements of the officers of the court to the court, the court's going to find that Ms. McKnight is a qualified candidate for the pretrial intervention contract program with the Van Zandt County DA's office. And the court this date will approve that contract for a period of 2 years with a $500 pretrial intervention contract fee. Court orders 100 hours of community service restitution and orders her to pay $750 as part of that contract for the reimbursement to Van Zandt County for the indigent attorney fees. So I'm going to order you to go ahead and report to the Van Zandt County Probation Office today before 4 p.m. at 250 East Groves, which is 2 blocks north of the courthouse. And do you know where that is, Ms. McKnight?
Yes,
Okay. Have you been reporting there on pretrial release?
no,
Okay. Well, it's important that you report there today, and then they will give you additional information. Okay.
okay,
All right. So you're free to go and go ahead and report to the probation department, and they'll give you more directions when you get there.
okay.
Thanks, Judge. Can we be excused for just a moment?
Yes, sir.
Yeah, I don't want to do it. No, that's where you bring that $500 from the state. Additional. As a probation.
It's what? No?
Okay.
No.
Well, then just go.
Where's your-
No, to the DA's.
Well,
Hey,
no.
Ms. Smith, are you there? Candace Smith?
Yes, sir.
All right, Ms. Smith, this is Judge Chris Martin here in Van Zandt County. Mr. Stevens, your attorney, has not logged on for the 1:30 hearing. You were supposed to appear by Zoom this morning at 9 a.m. and
Yes, sir.
When you didn't, the court has rescheduled you until this time. Have you been in contact with Mr. Stevens?
I've been trying to call him, but I think we might be playing phone tag or something like that because, like I can't get a hold of him and it's like he can't get a hold of me. And I don't know. I think we're just, it's mass confusion, but like, I think that if, I just stay on it, I could get a hold of him.
All right, Ms. Smith, you were set for arraignment today for a charge of possession of a controlled substance in penalty group 1, less than 1 gram. Have you spoken to Mr. Stevens about this charge?
No, sir. I have not.
Okay. Well, let me ask you, is your name Candace Kaylin Smith?
Yes, sir.
I'm going to ask you if your name is spelled correctly in this indictment that I'm reviewing. It is spelled Candice, middle name Kaylin, Caylynn, last name Smith. Is that name spelled correctly?
Yes, sir.
Ms. Smith, I'm going to read to you the indictment in this case, okay? It says that
Yes, sir.
it says that the grand jury for the county of Van Zant, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January term AD 2020 of the 294th Judicial District Court for said county, upon their oaths present in and to said court at said term, that Candace Kaylin Smith, hereinafter styled defendant, on or about June 12th of 2020 and before the presentment of this indictment in the county and state aforesaid, did then and there intentionally and knowingly possess a controlled substance, namely methamphetamine, in an amount of less than 1 gram against the peace and dignity of the state, signed by the foreman of the grand jury. And this indictment is charging you with a state jail felony offense in the health and safety code, which is possession of a controlled substance in penalty group 1, 1 gram. Do you understand what you have been charged with and alleged to have it done?
Yes, sir.
Okay. Miss Smith, your attorney is not here today, but if he were here today for purposes of arraignment, he would explain to you that the range of punishment for a state jail felony, if you were convicted of this offense and sentenced by either a judge or a jury, is that you could receive imprisonment time of not less than 6 months or more than 2 years in a state jail division of the prison. Understand that?
Yes, sir.
And so what I'm going to do at this time, Ms. Smith, is I'm about to ask you, how do you plead to this charge? And if Mr. Bill Stevens were here today, he would recommend that you enter a plea of not guilty at this time so that he would have time that he could speak with the prosecutors and learn more about your case, okay? You understand?
Yes, sir.
So at this
Yes, sir.
At this time, I'm going to ask you, how do you wish the court to enter your plea on this charge at arraignment? Not guilty, is that correct?
Yes, sir. Not guilty.
All right. So, Ms. Smith, I'm going to find that the court has admonished you about the indictment in this case, that you understand the range of punishment, that you understand what you've been charged with, and that you have entered a plea of not guilty before the court. And Ms. Smith, I'm going to set another court date for you on March 11th at 9 a.m. Okay?
Yes, sir.
March 11th, I want you to, in the meantime, I want you to contact Mr. Stevens, and y'all need to have a conversation about this case and be prepared to appear before the court and make another announcement on your case, okay? On March 11th at 9 a.m. And you'll appear via Zoom. You'll appear via Zoom that day as well. Do you understand?
Yes, sir.
Okay. Other than that, I want you to stay in contact with your bondsman, Roy Brockway Bell Bonds, and your attorney, Mr. Bill Stevens. Do you have any questions?
No, sir. Thank you.
You're welcome. Ms. Smith, you're free to go.
Thank you, sir.
You're welcome.
says we're ready.
All right, Mr. Ashmore, who are you ready on?
We're ready on Miss Mary Elizabeth Rumbo, cause number 2020-00512.
I don't have that one. I've got CR 2270 and CR 2271 on Mary Elizabeth Rumbo.
Judge, those two cases are going to be taken into consideration with the misdemeanor DWI.
Ooh, I don't think I have a misdemeanor DWI in my court. Do I?
Judge, I thought we had filed a motion to transfer, and if we haven't, that's on me. I thought we had done that already, and if I didn't check that box, my apologies. I can probably have that done with an email or two, and we can recall this and go ahead and do Mr. Dell.
I'm just going to check the clerk's file real quick. Yeah, unfortunately, the DWI is not filed in my court, so. Do you think you could have that done by your office while we're?
Yeah, I'll shoot a quick email. So just sit down for 1 second. We got one more little hurdle. And can we do Mr. Dell, Your Honor?
All right, Mr. Dole. PR 2142, State versus Austin Tyler Dole. I believe we're set for arraignment, but also have an indication of perhaps a plea.
Yes, sir, Your Honor. We have a plea agreement for 3 years, TDCJ, to run concurrent on CR 210042, which is the third-degree felony evading arrest with a vehicle, as well as on cause number FC 20-00028, the third-degree felony driving while intoxicated third.
Can you repeat the evading cause number for me?
Yes, Judge, it's CR 21-00042, Your Honor.
Any fine?
The fine is $2,000 on the evading and $2,100 on the DWI, along with restitution of $60 on the DWI court costs, of $290 on both cases, reimbursement of $15 on both cases.
And is the FC charge, is that a unindicted charge? It's indicted. I don't know that the FC charge is in my court either.
Judge, my understanding is that was indicted and sent downstairs as well.
So do we need another motion to consolidate, Judge?
I'm gonna look at the clerk's file. Yes, I see there was an information filed in the CCL on 2/5. So right now that court has the jurisdiction on this case. So if you wanted to file a motion to transfer and get Judge Winters to sign that in e-file and send it to me, then I can accept it, and then the clerks would have to pull it over. I don't know how long that's going to take.
Judge, I believe you're looking at the evading arrest was filed by information a couple of days ago. The DWI was indicted 5/4/2020.
Okay, but still not in this court, correct?
No, Judge. It was used by the 294th grand jury, but then was assigned number downstairs.
Judge, looks like we have some paperwork to do that might take some float time. I've got 2 hearings on Thursday. I don't want to, I'm trying to clean up my business on the court's docket. And if we can't get that done before 5, realistically, is Thursday morning a possibility so we can square this away? So that's two motions and 2 orders that need to be signed, and I think it's doable, but I don't want to ask the court to be too generous with time.
Mr. Dole would have to be in the afternoon because he's going to TDC, correct?
He is.
And then Miss Rumbo is she going to time or is she going to
No, it's probation.
State? Do you have any objection to moving these cases to Thursday's docket?
We do not, Your Honor.
Do we have availability on Thursday's docket? Let's see, Thursday, the 11th. Let's just do that, Mr. Ashmore, because I think it's going to take more time than we anticipate. So, Mr. Dole, I'm just going to reset your plea to Thursday at 1:30. And you can tell Miss Rumbo she's still in the courtroom with you.
Yeah, she's right here.
Ms. Rumbo, your case is going to be reset also to Thursday. Do we already have the paperwork signed on Ms. Rumbo?
Yeah, we have everything except that motion to transfer / consolidate, which like I said, Judge, I thought we had that box checked.
And she's going to probation, correct?
That is correct, Your Honor.
All right, then Ms. Rumbo, you're going to appear either at the courthouse or you're going to appear via Zoom. I don't know what you're capable of doing or not doing, so I'll let you work that out with Mr. Ashmore. But either way, you're going to report back to the court on Thursday at 9 a.m. to enter your plea.
Okay. All right, Judge, thanks.
So Ms. Rumbo, you're free to go. Mr. Dole, we'll see you on Thursday as well.
All right, have a seat. We'll get this squared away.
Do you have anybody else that you're ready on, Mr. Ashmore?
Yeah, yes, Your Honor. We got Ms. Munoz, we're ready.
All right, this is cause number CR 20183 and F1915, State versus Candace Lachelle Munoz. Set for docket call today.
Judge, we have a plea that the state and Ms. Munoz and I have agreed to. It is well, let's not jump the gun. Are we going to have another consolidation problem? We got an unindicted F19-00015 fraudulent finance statement and a 1245 of this court CR 20-00183. I'm hoping that's not going to be another failure on my part to consolidate these. You're muted, Judge.
I know it's because I don't want you to hear what I'm talking about.
Yeah, it's kind of, I figured that was.
Judge, the fraudulent filing of financial statement was indicted. I'm not sure why it was given F19-00015. It was indicted in that appears to be the 294th Judicial District Court.
We may just have a bad judgment. Cover page then.
No, that's the number that was written on the indictment.
I show it's been assigned to the county court of law. It was filed on 2/6/19 in the county court of law. I do see that on October 14th, that there was an order on motion to consolidate, filed but not signed. So it looks like, Mr. Ashmore, there's a motion to consolidate, but there's no order granting it by the county court of law. So this appears to be another case that would need to be. Do you want Miss Taberham to see if she can assist in getting this signed today?
Absolutely. And if I need to refile that order.
No, we've got the order.
Okay.
Apparently it was never acted on by the county court of law. So Miss Taberham's going to go and see if she can present it to Judge Winters and see if he has time to sign it. If he does, then we'll do that and we'll get it signed and then we'll go forward. So you can just go ahead and have her have a seat and we'll recall her in just a moment. Do you have anyone else that you're ready on?
Yeah, we have Ms. Rodriguez set for an MTR today. We have an announcement we are ready to make.
All right, if Ms. Rodriguez would step up. This is cause number CR 14419 and FC 255, State versus Frankie Francine Rodriguez. Go ahead, Mr. Ashmore.
Ms. Rodriguez and I have been working with the state to resolve all of her matters, one of which includes this motion to revoke or adjudicate on a criminal mischief charge. And the offer from the state is 15 months and to 1245, the evading arrest. And we want to enter at least an announcement that we're going to accept that. There hasn't been time today to get the paperwork prepared. So I think if I'm coming back Thursday, if the court will allow us to just come back Thursday, so we do not wear out Miss Abney today on preparing plea paperwork, then we can resolve this case finally on Thursday.
Okay. Court will set Ms. Rodriguez then for Thursday, the 11th at 1:30. And I'll just go and give you the heads up that the FC 20 number is a county court of law case.
Of course it is.
Judge, that one will be 1245. So I don't know if it's necessary to do a transfer on something we're going to 1245. But if we do, just let us know.
Okay. And I do see that Judge, you know what? I am incorrect. I was going to tell you that Judge Winters has already ordered the transfer, but it's looks like it's filed in the wrong case. It was Frankie F. Montgomery.
Oh, that's her, Judge.
Oh, is it? Okay.
That's her, yes. And there was some confusion about that. That's her maiden name.
Well, Judge Winters ordered it, but I don't see where I've accepted it. So I don't see where it was ever presented to me. So, but if it's going to be 1245, as Ms. Heisel says, then it's not going to be a concern, except that it would need to have Judge Winters' signature on the dismissal. So I can either go ahead and accept that in and then 1245 it so the clerks can make sure that they properly close it out. Would you like me to do that?
Yes, Judge.
That's probably simplest.
Okay, then I'll go ahead and accept that and ask the clerk to get that set up before Thursday. And then we'll bring Ms. Rodriguez back at 1:30.
No, it's this one. Yeah, see, now you guys missed me. Now you get to see me all the time. Okay. Thank you. All three done. There, I gotta take that. See. I'm sorry, you did. We'll get you squared away. All right.
Are you done, Mr. Ashby?
Yeah, I think we're waiting a minute on Miss Munoz, so Candace, just hang out for a second and we'll get pulled back in, okay?
Bailiff, remind me, is Mr. Williams ready on, or with Mr. Stevens? Is John Charles Williams in the courtroom?
Mr. Williams is present in the courtroom, yes, Your Honor.
If you'll go ahead and step up.
Judge, can you hear me?
Yes, I can hear you. Can you see and hear me okay?
Yeah, I see you fine, Judge. I apologize for not being on here at 1:30. I was in the Henderson County Jail. I got stuck over there.
Did you get arrested or something?
No, luckily I didn't. They let me out, Judge.
Okay, good behavior. All right, this is cause number CR 19-224 and CR 2146, State versus John Charles Williams. And I show that we're set for pretrial in each case.
That's correct, Your Honor. We have no formal pretrial matters.
Okay. There being no formal pretrial matters, the court sets Mr. Williams then for docket call. I'm trying to see, have already set you for another time? I set you on March 11th on Miss Smith. So are you available on March 11th, Mr. Stevens?
Let me check with the judge. Yes, sir, I am.
Okay, good. We'll set Mr. Williams in for docket call on that date at 1:30.
All right, sir.
And Your Honor, I apologize, that's March 11th, correct?
March 11th. Yes, ma'am. 3/11.
Thank you.
That'll be at 1:30. If Mr. Williams is, if he's on bond or bail, then it'll be at 9 a.m.
All right, sir. Gotcha.
And Mr. Stevens, I went ahead and spoke with your client, Miss Smith.
Yes, sir.
She did appear via phone today as I had instructed her to do. And I've set her for pretrial also on March 11th.
All right, sir.
I went ahead and advised her of her rights, made sure that her name was spelled correctly in the indictment. She entered a plea of not guilty. The court let the record reflect that. And so we trial on March 11th.
All right, great. That'll be 9 o'clock, correct, Judge?
Correct, 9 o'clock, and told her she would need to be in contact with you. She indicated that y'all might have been playing phone tag. I told her she needs to stay in contact with you and that she would appear via Zoom again that day.
All right, sir.
All right, and I believe that's all you have. Is that correct?
All right. Yes, sir, I believe so.
All right, thank you, Mr. Stevens.
Thank you, Judge. Sorry I'm late.
No problem.
Your Honor,
Yes, ma'am.
Mr. Sanders is ready with his client if you'd like to.
Yes, step on up. Okay, go ahead and lock him in. All right, this is cause number CR 1642, State versus Jerry Wayne Lunsford. And Mr. Sanders, can you go ahead and give me an overview of the plea agreement?
Yes, Your Honor. The motion to adjudicate. He'll be pleading true to counts number 2 and 3. I believe the state was going to abandon count number 1. and the agreement is for a 7-month state jail sentence. And then the remaining of his financial obligation.
And does he have any credit time towards the sentence?
Yes, he has 90 days credit.
Or any other cases being discharged or dismissed?
We have several in the county court of law, but I think that would be a big issue to get them transferred here. I'm joking, Judge. That's all we have.
Okay. No wisecracks. Okay, I do that.
That's right. That's right. I apologize.
All right, give me just one moment and let me pull up his motion to adjudicate. And state, is that your agreement that you're going to abandon count one?
That is correct, Your Honor.
All right, Mr. Lunsford, if you'll raise your right hand, Mr. Lunsford, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, you may put your hand down. You are in fact Jerry Wayne Lunsford, is that right?
yes,
Mr. Lunsford, are you a United States citizen?
yes,
Do you read, write, and speak English?
yes,
Ever been diagnosed with any type of mental condition?
yes.
What have you been diagnosed with?
I'm bipolar, schizophrenic, and early stage of dementia.
Are you currently on any medication for those?
Take medication for them, yes, sir.
Do you feel like you have a rational understanding of today's proceedings?
I don't understand this.
Do you feel like you are clear-headed and you understand what's going on today and that any of your mental disorders are not affecting your ability to understand?
Yes.
Okay. Mr. Sanders, do you believe Mr. Lunsford to be competent today?
Yes, sir. I believe he is. And we did talk a little bit about some mental health issues, but during our discussions about the case itself and about his mental health issues, I believe that he understands what the violations of probation are, what the allegations are, and understands the consequences of entering this plea agreement. So I believe he is competent.
Thank you, Mr. Sanders. All right, Mr. Lunsford, I'm having shown to you on the screen the state's motion to adjudicate, which was filed on November 18th of 2020 at 10:45. Here it says that you appeared before the court on December 13th of 2016, and you pled guilty to the offense of possession of a controlled substance in penalty group 1, less than 1 gram, a state jail felony offense. Also says that the court reviewed the evidence, found that there was enough evidence to convict you of that offense. However, the court did not convict you on that day. Rather, the court deferred a finding of guilt and placed you on community supervision for 4 years. And the court also assessed a $1,500 fine. It was during that term of your community supervision that the state filed this document. And in this document, they have alleged in counts 1, count 2, and count 3 of ways that they allege that you have violated your community supervision. Does your client waive the formal reading of the state's motion at this time, Mr. Sanders?
Yes, Your Honor. We waive the reading of the motion to adjudicate.
So at this time, the court's going to find that the state has agreed to withdraw count 1, abandon count 1, and that the state is proceeding on count 2 and also on count 3. Is that correct, state?
Yes, Your Honor.
All right, thank you. All right, Mr. Lunsford, at this time, I'm going to ask you, how do you plead to count 2 and also count 3 as contained in the state's motion to adjudicate? Are those counts true or not true?
True.
And Mr. Lunsford, are you telling me that those counts are true because in fact they are true and for no other reason? And Mr. Lunsford, has anyone threatened you or forced you or told you you had to plead true to those counts? And are you pleased with Mr. Sanders' representation of you? Do you feel like you've had enough time to talk to him about your case and have all your legal questions answered?
Yes,
And you're pleased with what kind of legal work he's done for you?
yes.
All right, the court will find that Mr. Lunsford's plea of true is voluntary, will accept the defendant's plea. Mr. Sanders, any objection to the admission into evidence of the defendant's waiver of rights and plea of true?
No objection.
All right, court admits that into evidence and takes judicial notice of Mr. Lunsford's judicial confession. Is there anything further from the state,
No, Your Honor.
from the defense?
No, Your Honor.
That being the case, the court will find that based on the evidence that Mr. Lunsford has in fact violated his community supervision. Court will follow the plea agreement in this case. Court finds that Mr. Lunsford has violated counts 2 and 3. Court hereby revokes his community supervision, adjudicates his guilt, and assesses his punishment at 7 months confinement in the State Jail Division of TDC. The court orders Mr. Lunsford to pay the balance of his financial obligations, and the court awards Mr. Lunsford 90 days towards the sentence in this case for the time that he has spent in jail on this cause. Mr. Lunsford, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. If you have not been fingerprinted at this time, I'll have you go with my bailiff to be fingerprinted, and then good luck to you, sir. Mr. Sanders?
Yes, Your Honor.
Mr. Key is at the courthouse. Would you want to do your hearing from there, or do you want to come back to the courthouse? It's
I'll come back to the courthouse. That might be easier. So
Okay, all right.
I'll be back there in a few minutes.
Thanks, sir.
Or do you have any more that you're waiting to do over here?
Say that again?
Do you have any other hearings over here at the jail, or because basically if it's just Mr. Key's case that's left, then I can just go ahead and do that right now. But,
I do have more at the jail.
okay.
You're Mr. Ashmore's client, correct? Mr. Ashmore's client, Mr. Ashmore's client. Mr. Sanders, hang on just a second. Judge Martin,
Yes, ma'am.
I think the only people present are Mr. Ashmore's clients who just walked in the room. Mr. Ashmore, are you ready to get in front of the judge again, or can Mr. Sanders?
No.
or something?
Yeah, no, I think we're still waiting on that order.
Do you show something differently, sir?
I show that all the inmates are done, but I do show that we still have more of Mr. Ashmore's clients, at my understanding, where they were reporting to the jail. And so I believe that we're going to do the plea on Ms. Munoz, who's there. And so I do have an order on the motion to consolidate, and that's been signed by Judge Winter. So I believe that that's being processed in at this time.
Okay, yes, sir. Hey, this is Erin. I am on my own now, and I have 3 people who are ready. Could you come do a pickup for me? Thank you. Bye-bye.
All right, with Judge Winter signing that order on the motion to consolidate, I will also sign to accept that into my court. So I'm comfortable to go ahead and go forward with Ms. Munoz at this time.
All right, Judge, thank you. This is Casey Ashmore on behalf of Candace Munoz. Cause number F19-00015. Your Honor, this is a plea on a fraudulent finance statement, basically government benefits, social welfare benefits. It was charged in May 2018. It's a state jail felony. The terms of the plea agreement are a plea of guilty 2 years TDCJ, state jail probated for 5. She has a significant restitution. The state has agreed to no fine because that restitution amount of $15,833.23. And that the state will also 1245 cause number CR 20-00183. Court costs $290 reimbursement, $715. Community supervision terms are,
Well, that's okay on the community supervision terms. So, court cost of $290 and reimbursement is $715.
that's right, Your Honor.
Restitution of $15,833.23.
That's correct, Your Honor.
And then 2 years TDC, state jail probated for 5.
Correct, Your Honor.
Okay. Anything else?
There's not a clerk here to swear to this, so we probably need to go on the record for a minute and put Ms. Munoz under oath. There's nothing to worry about, but normally the clerk would swear you to some of those places, and the judge is going to have that testimony right now, okay?
All right, Ms. Munoz, if you will you raise your right hand for me, ma'am? Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you put your hand down. Because you are wearing a mask and you're a little bit further away from the microphone, make sure that you speak up loudly. You don't have to take your mask off. I'm just saying, make sure that you speak up loudly so that my court reporter can take down everything that you say, okay? All right, are you Candace Lachelle Munoz?
Yes.
And are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes.
Do you feel like you've had enough time to talk to him about your cases and have all your legal questions answered?
Yes.
Is there anything about this plea agreement and the paperwork that you signed and reviewed that you do not understand?
No.
Throughout the paperwork where your signature appears, are you telling the court that that is your true and correct signature and you've only placed it there acknowledging that you understand what you've read?
Yes.
Mr. Ashmore, do you believe Ms. Munoz to be competent today?
I do, Your Honor.
And you've explained to her her legal and constitutional rights?
I did, Your Honor.
And you've also explained to her how community supervision works?
Yes, Your Honor.
Ms. Munoz,
Including the sanctions for possible missteps and how those sanctions ultimately might result in a motion to adjudicate guilt or revoke, how the documents that we're agreeing to for the fraudulent finance statement charge could be used conclusively in a motion to revoke or adjudicate guilt. But we've discussed that.
thank you, sir.
Yes, Judge.
Ms. Munoz, you are charged by indictment with a state jail felony offense of fraudulent finance statement, and a state jail felony. That level of offense carries a specific range of punishment of not less than 6 months or more than 2 years confinement in the state jail division of TDC, and also an optional fine not to exceed $10,000, which means for you that if the court approves your plea agreement today and places you on community supervision, as you've discussed with Mr. Ashmore, if you violate your community supervision, the state could file a motion alleging that violation. And if the state proves that to the court could revoke your probation. The court could sentence you up to 2 years in the state jail division of TDC. Do you understand that?
Yes.
And so you understand that full range of punishment.
Yes.
At this time, Ms. Munoz, I'm going to ask you then, how do you plead to the state jail felony offense of fraudulent financial statement?
Guilty.
And Ms. Munoz, are you pleading guilty to that charge because you are guilty of committing that charge and for no other reason?
Yes.
Has anyone threatened you or forced you or pressured you to make you feel like you had to plead guilty to this offense today?
No.
All right, the court will accept Ms. Munoz's plea of guilt. Mr. Ashmore, any objection to the admission of the stipulation of evidence?
No, Your Honor.
The stipulation of evidence is admitted into evidence, and the court does take judicial notice of Ms. Munoz's judicial confession. Is there anything further from the state?
No, Your Honor.
from the defense?
No, except to say briefly, Your Honor, Ms. Munoz has had a very difficult year and a half in Van Zandt County. She's had an active CPS case, but I do think she's truly a candidate for success. She's been drug-free. She's shown to the state of Texas one of the reasons for the leniency the state has put here, even though $15,000 in restitution is not lenient. She owes that to the United States government. There's not a lot we can do about that, but her hard work to get her children back and to overcome the drug abuse that got her into this situation. And I just want her to, I commend you for taking responsibility for this. And I just want you to know that everybody here wants your success, your continued success, especially me, okay? Thank you, Your Honor.
Thank you, Mr. Ashmore. All right, State, can you give me a brief summation of the facts to support the plea?
Yes, Your Honor. Ms. Munoz basically filed some fraudulent documents for both, I believe it was CHIP and Medicaid. It was two government assistance programs in which she did not claim the father of her children as a resident of her home or claim his salary as part of their income. And then it was discovered through an investigation by the Inspector General that he was living in that home and contributing to the income of that home, and that would have basically made them not eligible for those benefits. So the benefits that were paid out is what we have agreed to restitution back to the U.S. government, Your Honor.
Thank you, Ms. Heisel. Any objection to that summation, Mr. Ashmore?
No, that's accurate, Your Honor.
All right, then based on the evidence, the court will follow the plea agreement in this case. The court will find that there is sufficient evidence to substantiate the guilt of Ms. Munoz for the state jail felony offense of fraudulent finance statement. The court hereby convicts her of that offense, assesses her punishment at 2 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will find it's in the defendant's best interest and that of the community for that sentence to be suspended and for her to be placed on community supervision for a period of 5 years. The court will order restitution in the amount of $15,833.23 payable to the agency victim in this case. The court assesses a zero fine. The court assesses court costs in the amount of $290 and orders Ms. Munoz to pay $715 reimbursement for the indigent fees and other fees in this case. The court also dismisses under section 1245, cause number CR 20183, the abandoning or endangering a child with criminal negligence. Ms. Munoz, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. If you haven't been fingerprinted on the judgment, I'm going to have you be fingerprinted at this time. After that, I need you to report to the Van Zandt County Probation Department at 250 East Groves, 1 block north of the courthouse, for further directions from that agency, okay? All right, good luck to you. Mr. Ashmore, do you know anything about Brianna Musgrove?
Yes, Judge, she was on this morning and I told her that she had some confusion, miscommunication from our office. We thought we told her to be here physically so we could collect a thumbprint, do her plea today. She misunderstood. I can get her back on Zoom. I told her she needed to remain available and be standing by. I think Wendy did text her. Wendy from my office did text her the Zoom ID. If you need to see her face for a reset, we can make that happen. Mr. Yates, same thing. And
well, let's before we go on. So
yeah.
we're on Miss Musgrove. So is Miss Musgrove going to enter a plea?
She is going to enter a plea, but we're just not, we fumbled the football on that one. She thought she could do it by Zoom. We didn't have communication with her that we needed her here in person to do the thumbprint. I'm not a big fan of doing the pleas over the Zoom.
Is she going to enter a plea to time or probation?
It's a probation, and
Shall we reset her until Thursday to come back with your other individuals?
Our plea offer is 3 deferred, $2,000 fine, court cost restitution on the drug test, $1,245 the remaining charges. And I will tell her she needs to be here on Thursday.
So I'm not going to take any action against her bond at this time since we're going to set her for Thursday. So she needs, if it's going to be to probation, do you want her to appear in the afternoon or in the morning?
She does live in Louisiana. She was a Louisiana resident at the time she was arrested. She didn't move there after the fact. And so an afternoon probably be more convenient for her.
Have you discussed the interstate compact with our probation department? So she's clear to go and be supervised in Louisiana. That's not going to be a curveball, is it?
It's not. As I understand it, this is her first offense, so it should be a no issue. And she has work and roots there such that the transfer, if she wishes to do it, should she knows she has to pay for it, but if she wishes to do it, she can do that.
But you've already spoken with the probation department about that.
With our probation department? Yes,
Correct.
yes, not with Louisiana. No, not with that parish where she lives.
Okay, so she's eligible for transfer as far as out.
Sorry, we're sidebar. I'll forgive me, Judge.
Okay, so but you've spoken with them and she's eligible for transfer on the interstate compact at this time.
I guess that was your question, Ms. Burns, because you need her driver's license.
Is Ms. Burns there with you? Okay, I didn't know.
Your Honor, I had told Mr. Ashmore that I need a copy of her driver's license to have proof that she has resided in Louisiana for 6 months. So if that's the case, then she will be eligible to transfer to Louisiana. But if not, then they'll both be the process of a 45-day wait.
And just so you know, Your Honor, I'm looking at my email. Our office called Ms. Musgrove to get that for Ms. Burns, and we have that, and I'm going to forward that email right now with the front and back of Ms. Musgrove's driver's license.
All right, so I'm going to excuse her appearance for today, and we're going to set her for Thursday. And you requested 1:30 to give her travel time. Is that correct?
Yes.
All right, it'd probably be best for her to appear over here at the Van Zandt County Courthouse in my video conference room rather than at the jail.
Yes, Your Honor.
All right, now Robert Yates. I believe was he reset already for March 23rd?
He was reset. He was present on the Zoom.
Okay.
With Ms. Tabraham and me, and that is reset at the defendant's request. Just
Vincent Ojeda, I noticed that we had him in our conference, our online waiting room, but he's not there at this time. If you can get him back on, then we'll bring him in and we'll conduct our Zoom hearing with him.
I will do that, Your Honor. And just so you're aware, he was at the courthouse this morning. And this is going to be a pretty simple request. There was a motion to speed up the discharge of probation. We're going to withdraw that motion because one, we don't want the adult probation department thinking we're trying to get out of something early when we haven't earned it. Mr. Ojeda is trying to join the United States Army. We had some problems on December 17th with getting his recruiter here because of COVID or whatever's going on in their office. And he has a hand injury that prevented him from working in December and most of January, but he did get cleared for work in February, did his first Monday of the year, this last Monday. But right now, I think, Judge, we're just going to withdraw that until he can physically get back on his feet. I'm texting him now to get back on Zoom
Well, if you're going to withdraw the motion, and that's the why we had a hearing today, if the state's not looking to impose any action on him, then you can just withdraw that and we won't need his appearance.
Yeah, and again, he was at the courthouse, Your Honor, and respectfully, we're just trying to get this kid into the Army. This is a, credit card abuse under $1,000. It might have been under $500. So, well, he's getting back on. I'll just tell him we're excused for now, and we may re-advance this motion after we confer with probation in the state as he gets closer to getting more in compliance.
Okay.
Judge, state has no objection to doing so.
Okay. All right. And so I think that resolves, I think Mr. Devine is the only other one, and I think we're waiting till 4 p.m. to see if he is tested positive. He's in the Hunt County Jail, it's my understanding, and that he's undergone a COVID test. And if he's negative, then he's going to appear at 4. If he's positive, then he will not be appearing at 4, is my understanding. So that's about 20 minutes.
Well, Judge, I've got an idea, because we have a new set of plea papers, not the plea papers that I took him last night, and they needed signatures. So it's a little later than I thought we'd be finished with business, and that's my fault. But if I can be excused, I'll head there, because I still need signatures on all those documents. It's just later than I anticipated.
Okay. How long do you think it's going to take you, though? What, 45 minutes to get there, though, right?
At least, Judge. But I'll head right there.
Yeah, but I don't think you're going to be able to do all that before 5 o'clock, because it's almost 4 now.
I drive pretty fast, Judge. No, I'm just kidding. I'm kidding.
Don't do it in Vincent County.
I'm just kidding. I don't want to appear before you tomorrow.
Let's reset him to Thursday.
Yes.
And then you can get the paper. You can go ahead and head that way, and you get the paperwork signed. And then when you come back on Thursday, or whatever you got to do to get the paperwork back to us, then we'll take him up at that time.
Okay, Judge. Can I ask one, just a placeholder? Oh, my colleague Brad Johnson is out this week, and I may have to cover a temporary orders hearing at some time in the afternoon on Thursday. So I'm going to try to make it not interrupt our business, but hopefully it won't. But I may have to pinch hit on that, Your Honor. So we'll just, if that's all right, I just didn't want to be disrespectful, that I know that conflict may arise.
Do you know how long? Because you've got a bunch of people set for Thursday.
No, I just have the 2 in the morning and then these 3 pleas.
Well, yeah, 3 pleas in the afternoon plus Mr. Devine, right? 4 pleas in the afternoon.
Well, the good thing about temporary orders, you only get 20 minutes aside, so it'll be fast.
Okay. So if Mr. Devine comes on at 4 p.m. with Hunt County, I'll just tell him that we've reset him to Thursday and that you're going to come visit him.
Yeah, that sounds great. And should we wait a minute and make an announcement on what that plea is going to be, or should I just head that way and get signatures, Judge?
Go ahead and head that way and get signatures, and then take him up on Thursday.
Judge, if he does have COVID, are they going to allow them to get signatures from him? Is the jail going to be able to facilitate that?
I saw him last night, so I mean, he was behind the glass. We didn't high five.
Do you think, Mr. Ashmore, that you could still get a signature? Even if
we have been, I think I have to go if we're going to make this work. And we've been trying with the phone and whatever's going on in the Hunt County Detention Facility. I think they've had a COVID problem with their sheriff department. And I think if I don't physically go, we're not going to get this across the goal line. So I'm going to go and try and see what happens. And then that way, at least we'll be maybe done with that case on Thursday.
Okay, go ahead and head that way.
All right, Judge. Thank you.
All right, thanks, sir.
Excuse me.
Yes, sir. Thank you.
Keep it slow, Mr. Ashmore.
Right. where is all that? Where did that-
You're wearing something else on me,
Hey, Deputy McLeish.
I got my answer, Your Honor.
Okay, thank you very much. So you got everything you need?
Yes, sir. Thank you.
Excellent, thank you.
Oh, the attachment?
Okay, Jeff's back over here.
I'll be with you in just a moment, Mr. Sanders. Mr. Sanders and State, I'm going to wait and get an update from Mr. Waddell regarding Mr. Key, and then we'll call his hearing. And Mr. Waddell is indisposed at the moment. Should just be a minute or two.
Thank you, Your Honor.
Judge, could you and I go into a breakout room on an unrelated matter while we're waiting on that process to happen?
Yes, ma'am.
Thank you.
Mr. Sanders, are you ready on Mr. Key?
Yes, Judge, we're ready.
All right, this is cause number CR 253, State versus Joshua Daniel Key. We're set for docket call today. Any announcement as to this case, Mr. Sanders?
Judge, we have an offer from the state and we're still talking, I've been kind of going over that with Mr. Key. I was going to ask if we could set it for one more docket call, and I think we probably should be able to get this resolved. But at least that's where we are right now.
Any position from the state?
Judge, we just extended an offer, I believe yesterday, maybe the day before. I guess it would have been yesterday because today's Tuesday, to Mr. Sanders. We would not have any objection to resetting. Allow him a chance to advise his client as to that offer and their steps forward from there.
All right, so what I'll do is I'll set Mr. Key. I'm not going to set him very long, Mr. Sanders. I'm going to set him for
That's fine.
Are you available on the 18th?
Yes, yeah, that'd be fine, Judge.
All right, I'm going to set him for docket call on February 18th. So that's going to give him a little more than a week to decide if he wants to accept that offer or not. Some other concerns that I need Mr. Key to be aware of. Mr. Key, you are on conditions of pretrial release. You do require the GPS monitor.
Yes, sir, Your Honor.
The GPS monitor must be charged.
Yes, sir, I've been charging that. It's a button to reset it, Your Honor.
I understand. You need to make sure that that thing is charged sufficiently at all times so that it can do its job, so that I can know where you're at and where you're not at. You understand?
Yes, sir, Your Honor.
If I call my probation officer and I want them to tell me where you're at and they can't do it because that battery has drained down and you've not charged it, and there's no excuse for that thing not charging.
Yes, sir. I've been charging, but it's been messing up too. Mr.
Well,
Waddell can tell you that.
I need that thing working at all times. If it's not working, then I'm just going to put you back in jail.
Okay.
That way,
Yes, sir, Your Honor.
that way I know where you're at. You understand?
Okay. Thank you, Your Honor.
All right. So if that thing's not working, you better be on the phone with Mr. Waddell and you better be telling him about it. And it better be because it's messed up and not because you're not charging it. Because if he tells me you're not charging it and you're not taking it serious, then I'm going to show you how serious I am about it. You understand?
Yes, sir, Your Honor. I understand.
All right. You stay in contact with Mr. Sanders and Mr. Waddell, and I'm going to see you back on February 18th.
Okay. Thank you so much, Your Honor.
All right. You're welcome. Thank you, Mr. Sanders, for going back and forth today. I appreciate you doing that.
Oh, yeah, there's no problem, Judge.
Thank you, sir.
All right, we'll see y'all later.
See ya. Mr. Woodwike, I don't know if we've missed anything. I've got everybody marked off on mine.
The only thing I don't know what happened to is Casey's client, Mr. Raymond Howard. Was that reset?
It was set, it wasn't reset. It was moved from pretrial to docket call. He had one already set on docket call, and then his new cases, he has 4 new ones, 252 through 250, through 254, and then CR 2343. We moved all those to docket call on 323. So now they're all at the same level.
Yes, Judge. Okay. I had not heard that part. That's the only one I didn't have a notation for.
Okay, so that's going to end our docket for today.